MConnect's crash course on intellectual property. My name is Jennifer Judge Hensel, and I'm going to be your host today. I'm with the University of Michigan College of Engineering, and I'm joined today by our two experts. We have Bryce Pills, a law professor at the University of Michigan, working in the Entrepreneurship Clinic. Hi, Bryce. Thanks for being here again.
Hi, Jennifer. Thanks for having me.
And also with us today, we have Marcus Sproul, who is a partner and registered patent attorney with Foley & Lardner, LLP. Hi, Marcus. Thanks for joining us.
Hi, Jennifer. Great to be here.
So we're here today to talk about intellectual property and specifically about the world beyond patents. We're going to be diving into trademarks, copyrights, and your overall intellectual property strategy. This course is brought to you by MConnects, which is an alumni engagement program at Michigan Engineering. You can find out more about the program, maybe participate in a webcast, watch a lecture on demand, or some research videos by going to www.engine.umich.edu/mconnects. So I want to remind everyone that this is a Q&A format, so we really encourage you to ask any and all questions throughout the programming. They could be about general trademark or intellectual property law, or even specific to your idea or product. The more relative this is to you, the better we're going to be. If you're watching it on the MConnects website, you can scroll right down to the bottom and put it in the discussion field. But you can also add them to, or you could tweet them to us at MConnects. Or if you're watching them on the Google Hangout or the YouTube page, you can put them right there. We're going to be looking at all four areas today. So a quick disclaimer here. The information in this program is provided for informational and educational purposes and does not constitute legal advice. You should consult your own attorney with your specific legal questions. University employees should consult their Office of Technology Transfer concerning university inventions. The information provided in this program is general in nature and does not necessarily reflect the views or positions of any university, law firm, or client associated with any instructor or guest. So with that, let's go ahead and get started. Bryce, do you want to go ahead and summarize this week's topic and maybe some key points from the videos?
Yeah, sure, Jennifer. Hi, everyone. So as you recall, last week we did a deep dive on patents. And when we were talking about patents last week, we were talking about what we call utility patents. And as you recall, a patent is a really broad form of protection. It can be difficult to get. You need to go through a costly and lengthy examination process. But if you get it, you have this relatively broad monopoly to prevent others from making, using, selling, offering to sell your claimed invention anywhere in this country. So this week we talk about other forms of intellectual property protection. So for example, if you didn't think you were able to get a patent on your new product or service, or maybe you wanted to flesh out the competitive advantage that you're seeking to obtain through intellectual property, what are the other ways to do that? And in the videos this week, you learned about design patents, which is another form of patent that protects the ornamental design of a product. We talked about copyright, which is an automatic form of protection that covers any form of original expression, such as graphics on a screen or source code, or someone's commercial, maybe the lyrics in their advertising. We learned about trade secrets, which is information that you're able to keep secret through reasonable efforts, where there's economic value from the fact that others don't know this information. And we also talked about trademarks. So a mark or some form of identifier that identifies the source of your goods or services. And now today we're going to take a little bit of a deeper dive. So last week we used as an example Gillette's Mach 3 razor, and we talked about ways that someone, if they came up with the progressive blade geometry in this razor, how they could use utility patents and some of the pitfalls that arise in trying to get utility patent protection. Maybe we can use this as an example to talk about these other forms of protection. So Marcus, maybe I'll throw it over to you. Thanks for joining us. Maybe let's focus first on design patents. Is there a way that someone could use design patent protection for a commercial product such as a Mach 3 razor like this?
Yeah, absolutely, and we do it all the time. If you want to keep it held up there, I don't know if people can see it. I guess if I'm talking, then you're not on. But the stylized handle is something that I think would be very well suited for design patent protection. The way that those rubber grips on the top surface are configured aren't necessarily functional. Certainly there are functional aspects of that might be the subject of utility coverage, but the way that those are designed would be very well suited for design protection. to go after people who might use that as something that is confusing to consumers.
Great. And so, do I have it right that whereas a utility patent would protect a particular structure or maybe functionality of this razor, such as the progressive blade geometry of the razors, the design patent's going to protect how this looks, the actual design of it, but not the functionality?
That's absolutely right. Yep, it's the look and feel, and it's not necessarily, some might say with design patents it's a relatively weak form of protection because it does just protect the look and feel, but you can craft design patents in a way that have broad scope so that you can get all the colorable variations of those designs that somebody else might try to put into the market.
Yeah, and we do hear that a lot, that people think design patents, because do I have it right that in a utility patent, someone's going to use words to describe your claim? They're going to say a razor with a guard, a cap, and 3 blades with this particular layout of the blades. Whereas for a design patent, you're going to draw a picture, right, and use lines to draw your design. So, what exactly do sophisticated companies or law firms do to kind of beef up that protection? Because it does seem that you could have a design patent that draws the particular ornamental design of these rubber grips here, but someone could tweak that design a little bit and maybe get around a single design patent. So are there strategies you use to kind of flesh out that protection?
Yeah, so if we think about a design patent for an ornamental design of a product, the narrowest version of that would be if you had every single line that you saw on the product itself in solid lines. The way that we broaden protection in the design patent world is you are allowed to use dash lines. And what the dash lines mean, those are parts of the design that you're disclaiming. In other words, you're not claiming them. So what we'll typically do in a case like this is we would have a design patent application that would probably have multiple embodiments going after different features of that design with everything else dashed out. So one example with the razor would be perhaps we would have a design where everything about the design is in dash lines except for maybe those grips. And maybe even we use break lines on those grips themselves to give us the ability to claim wider or narrower grips, things that are longer or shorter. There are crafty ways that we can do that to give design patents really, really broad protection to provide a more robust form of protection than one otherwise might be able to get if they had everything in solid lines.
So I just want to remind everyone today that we're talking about the world beyond patents. So although we are not necessarily diving into how to do patents, which we did last week, we are going to talk about things like copyright and trademark as well. So if you have any questions regarding those things, please feel free to go ahead and add them into the Google Hangout or the website or tweet to us at MConnects. So let me ask you guys, if somebody is interested in going with the design patent, how different does the design have to be from what's already out in the market, and how can they find out what's already out there with a prior art search?
Some people will do sort of prior art searching to figure out whether their design is new and novel. The test, at least from the patent office's perspective, it's a very easy threshold to meet. If you are even a little bit different than a design that's out there in some fundamental way, then you will not have much trouble getting your design through the patent office. Design patents are not examined to the same depth as utility patents. I think it's more there's more a belief that the differences in the ornamental designs are easier to see, and so I think that the patent office kind of lets things go through that are different enough and lets the owners fight it out when it comes time to enforce those.
Yep. Marcus, one thing we hear some of our entrepreneur clients asking is, how can they do their own prior art search for design patents? I think they can figure out how to do this for utility patents because the claims are words, and so they can do some basic keyword searches online, but it's a little bit hard to search for lines. Do you have any thoughts on that? Is there anything more than just knowing the companies in this space, or maybe looking at classification?
It really, yeah, that's really what it comes down to. It is difficult to search designs, and we worked on a portfolio for a client where the previous counsel had done prior art searching for every single design that they wanted to patent. It became a mammoth exercise, and frankly, it didn't provide them with all that much more information than the engineers themselves were aware of as to what's out there. So I think personally for designs, the best thing you can look at from prior art is just doing some simple Google searching to figure out what types of products are out there like it. And if there is a difference between what you have and what others have that makes yours distinct, I think that's something that you ought to consider pursuing to the extent that it's non-functional, it's only ornamental and aesthetic.
Great, thanks. So just to give people a sense of the scale of the amount of design patenting going on out there, since we're kind of using Gillette as our example, I did a quick search to try to find out whether they had design patents and how many. And from some quick searching, so this may not be totally accurate, I found at least 490 issued design patents in Gillette's name, most of them in the packaging classification or in the cosmetics and toilet articles classification, several on the handle for the razor, as Marcus mentioned. So they're aggressively pursuing design patents, and I think the number is even higher for a company like Apple or Samsung that are using these pretty aggressively on their new electronics and mobile devices. So Marcus, let's maybe move to copyright now and talk about, is there any way that someone could use copyright as a form of protection? Maybe let's first focus on the actual product itself. Is there any way that copyright protects something like this?
Yeah, I think copyright has a place in that regime. I think by and large companies that are in the consumer product space that are protecting their product designs tend to go more design patent than they do copyright. Copyright tends to have more of a foothold in the electronic spaces, but I think even for a design like that, there can be some copyrightability in that shape. It is I would say, a narrower form of protection in that copyright was really designed, back in the 1700s to really go after people who were making direct copies of something. And so it's kind of a direct knockoff protection type regime. But for instance, when we talk about things like graphical user interfaces, some countries don't allow the full suite of protection from the design patent side for graphical user interfaces, and so we have to fall back on things like copyright. So I think these two things go hand in hand, and it's coming up by and large with a strategy that makes financial sense as well as gives sort of that nice, robust protection.
I think how we often explain to people is if there's going to be some copyrightable aspect to this, it has to be separate from the functional aspects. So if they were to put a picture or maybe write the lyrics to some saying on the handle, there could be copyright protection in that. But the shape of the handle, which is very functional, you probably wouldn't be able to get copyright protection on that, but maybe design protection stretches a little further into the design of something that's actually utilitarian.
Yeah, I think that's right. And it also bears noting that copyright has another place in the design of that product. There are underlying product drawings, say, that people might have, or CAD drawings that are out there describing how to make that. All those things are subject to copyright, potentially. And copyright's nice because copyright protection is automatic. You get it as soon as you create something and fix it in a tangible medium in the parlance of the field. And what that means basically is once you commit that drawing to your hard drive, once you put it in the CAD program, you have copyright protection. Now, there's an additional step of registration required if you want to go and actually enforce that, but it is a very low-cost way of providing some protection on the back end that will help in cases where you might be concerned that your drawings or other aspects of your process might be leaked and used by your competitors.
Right. So let's maybe move away from their product. Gillette's more than just this product. They also are very sophisticated in how they sell and market their products. Are there other aspects of their business model, maybe where they're using copyright a little bit more aggressively, or maybe where it applies a little bit better, maybe in their marketing or commercials or advertisements?
Yeah, I think that's right. You're right. You'll see copyright protection on their ads for sure. The way that they present things. Some of the less tangible things, I think, lend themselves very well to copyright protection.
Yeah, and just to give some more numbers, I just checked the copyright registry to see whether Gillette had registered any copyrights, and there was at least 372 copyright registrations, And you're right, they're almost all on their marketing. So, commercials that have come out, short videos, the music associated with them, they've been pretty aggressive in registering those. And as you mentioned, they don't have to register them. Copyright attaches automatically as soon as they kind of reduce that to writing, but they get some additional procedural benefits by registering them. So let's switch to, let's do trade secrets and talk about trade secret protection and maybe the ways that someone could use trade secret protection to provide a competitive advantage for something like this. Are there aspects of this that you see trade secret protection applying?
Yeah, and that's a trick with trade secrets, because trade secrets are those things that they provide commercial advantage to a company, but that aren't well known by the public. And it's a trade-off. So we often get that question, do I patent this? Do I use trade secrets? Trade secrets have a very big role in the manufacture of any product. And here's an example with the Gillette razor. The specific composition of the rubber used in those grips, or the colorant that's used in the grips, or perhaps the temperature or the processing speeds on the line, things that would not be readily ascertainable from the product itself, things that are in the background that people in the factory might know, or the engineers who designed it might know, but the public would not necessarily know. Those types of things, customer lists, things that are kind of in the background for our company. That's really where trade secret comes in, and we often find a tension with our clients as to, with a particular thing that might not be readily ascertainable. Compositions of matter, an area that I practice in a lot, are notorious for this, because if you want to protect the composition through patents, you have to disclose to the public exactly what that composition is. And that gives materials engineers pause, because they want to keep that proprietary process to themselves. And then we say, okay, then your trade-off is trade secret protection, because nobody's going to be able to reverse engineer this and figure this out. Maybe that's a better way for you to go. It's certainly a lower cost way to go, but you have to keep in mind that trade secret protection doesn't attach automatically. You have to actually do something to get it.
And maybe can you flesh that out a little bit more? What are some of the things that someone would have to do to get trade secret protection? You don't have to apply to the government for it, right? But what are some of the affirmative steps?
That's exactly right. So this is more sort of internal steps that one might take. We always talk about the Kentucky Fried Chicken recipe. There are people who know that recipe, but it's under lock and key. It's divided among people so that maybe not everybody has the entire formula. Maybe there are protections. When I was a engineering co-op student, I worked for a company that made brake formulations for automobiles. And the way that they addressed it was, when materials would come in, they would not be the name of the material or the performance criteria of the material or the properties of the material. They would come in with numbers like J355. And there would be somebody in the organization who would know what the specs were on that material, but the people on the line, for instance, wouldn't necessarily know all that went into it. So they couldn't reverse engineer easily that product. It's more of an internal approach to how you manage the flow of your information, how you control access to your information, and the constraints that you put on people who you disclose that information to. It really makes up sort of the trade secret universe.
So I just want to jump in here and remind everybody that this is a Q&A, so if you have any questions about your specific product, and maybe especially with startups, how you would apply this sort of trade secret technology in your area, please jump in and let us know. You can tweet them to @mconnects, add them to the website, or put them into the Google chat or YouTube Hangout. So Marcus, let me ask you, if I am a startup and it's just me and another guy, how do I choose between going for a design patent, going for a full patent, or maybe just sticking myself with trade secrets and hoping that that covers me?
Yeah, and I think it depends on what the product is and how it's positioned. So there are certain things that do not necessarily lend themselves well to utility protection. For instance, let's say you're entering into a very crowded field where there are 300 different types of products like what you're doing, and the only real differentiator is not functional, but really design. The aesthetics of it, the look and feel. Then we might counsel that client to go and look for design protection opportunities as opposed to utility, because that could be a long road without any viable outcome. On the other hand, if we have to keep in mind that design patents and utility patents have different terms. Design patents have a life that is 14 years from the date that they grant. Utility patents is have a life of 20 years from the date they are filed. So that may also play a role in what we recommend in terms of how we pursue protection. You may want a longer monopoly for something, and if we can get some utility protection on that, if it has functional aspects to it that really lend themselves to that, we probably go in that direction.
I think probably another point there is that it's not an either-or proposition. The smart way to address this is, these are all tools you have to flesh out a competitive advantage. And so you don't necessarily, there's maybe some times where there's a particular aspect that you either need a patent or keep as a trade secret, but in many ways, on the same consumer product or technology, you can have a number of these forms of protection that kind of flesh out the wall around your market.
Yeah, I think that's right. It really is. We are looking at how many arrows do we have in our quiver to protect what you have, and that Gillette razor is a perfect example of that. There's utility, design, probably some copyright, definitely some trade secret protection, all wrapped into that. And so it's never a great position to be in to only have one form of protection on something that lends itself to more, because you're selling yourself short. Now, in reality, getting back to your question, Jennifer, how do startups prioritize that? That's an excellent question. And typically, we look for, okay, if you have to have a spend that's associated with this, how can we do that in the smartest way so that you're using your dollars right up front in a way? So trademarks, for instance, those don't necessarily have a timing associated with them. So maybe that can be put off until later. Patents, both design and utility, have to be pursued before you disclose it to the public in the ideal world. And so we would counsel that, if there is utility protection available here and you want to protect yourself, you need to get that done sooner rather than later. And there are ways to structure that in a way to defer cost and stretch things out so that you secure your protection without necessarily being put in a financial crunch right up front. That can be spread out over time while the product is finding its footing in the marketplace.
So I have a question here on the Google Hangout from Ben. He says that he has a database that has some proprietary information in it, and he's wondering how he can best secure that, what he should choose.
Yeah, that's a great question. Marcus, you want to take the first stab? We see a lot of people talking about data now. In the age of big data, common question is, what is the way to protect this?
Yeah. So first and foremost, you do have copyright protection potentially in the arrangement of that data if it's something beyond just a flat table. But that's not something you have to proactively go out and do. Really, if it's important data that gives your company an advantage that nobody else would know, then we're looking at some form of trade secret protection. And the way that we counsel with data is we have to make sure that a company has its data locked down. Password protection, having only certain people having access to that data is a good way to start. Making sure that all the people who do have access to that information have an appropriate type of confidentiality agreement in place, whether it be in their employment agreement or whether it is a separate agreement that they sign so that they are aware that that is important proprietary confidential information that has value to the company, and that if they were to disclose that to somebody else inappropriately, that it would harm the company. Getting that out in front, I think, is a good step. And there is a lot of litigation in that area where people will leave one company, take documents, files, data with them, and all of a sudden the company's chief competitor has a very similar product or is going after a very similar customer base that they had developed over time. Trade secret protection does have teeth, and there are even criminal penalties in some cases for violations of that.
What do you see, Marcus, when someone actually wants to deliver the data or access to the data to their customer? That's part of their business model. Perhaps they have a bunch of genetic information in a database, and their business is going to be give us $50 and we'll give you access to this data. How can you protect it then? Because now you're starting to disseminate a little bit, and maybe it's a little bit harder to keep it as a trade secret. I think one way is probably copyright and having some terms of use attached to by paying these $50, here's what you agree to do with the data. Is there anything else anyone can do?
Yeah, there is an interplay certainly between intellectual property and contract law. So contractual provisions that restrict use, that restrict dissemination, those things should be part of any robust intellectual property program. Thinking about how one might put teeth into that. There's a common misconception that if you have an NDA, non-disclosure agreement in place with somebody, that you are protected and your trade secrets are fine. Well, if you look closely at those NDAs, they typically have a term. And that could be 3 years, 5 years, whatever that term may be. A common pitfall, though, is not to have an added layer of protection in there for things that qualify as trade secrets. Because one way to describe a non-disclosure agreement is an agreement to give you all my most important information with the full knowledge that once this expires, you can freely disclose it to everybody you want. If you start thinking about things in terms like that, then to ask for that additional protection in there, and we typically phrase it something along the lines of, your term of confidentiality is 3 years, but for anything that we designate as a trade secret, that protection shall survive the termination of this agreement and shall last for as long as that thing is held as a trade secret. So, contractual, once things are out of your own control, really contract law is probably one of the strongest forms of protection that you can have.
I think you raise a great point about NDAs. We see a lot of entrepreneurs just believing that an NDA is boilerproof, and as long as they have a document that's titled an NDA, they're okay. And I think something that people need to realize is if you need to enforce your NDA, the way to enforce it is going to court and having to prove that this company that's taking your information only had access to that information through you, and it was bound by this NDA. And that can be a very tough thing to prove. Most of these NDAs have an exception for something that the recipient was already developing, and it's just a very hard thing to prove. It doesn't fall under that exception.
Yeah, it is. So, keep your information close as long as you can, and if you need to, make sure that you have agreements of protection in place with some teeth in it that you can actually go enforce. Right.
So let's move to the one form of protection we haven't talked about yet, which is trademarks and maybe trade dress. Is there any way that could be used to protect aspects of a razor like this?
Yeah, so I saw that on the, I don't know if it was on the underside or the top side of that razor, there was the Mach 3 logo that was on there. That is one area. So if we keep trademarks for what they are, trademarks are intended to associate a product or service with a source. So in other words, if you were to see that trademark, you would know who produced it. Well, the Mach 3 is obviously a trademark of Gillette, but it has a stylized format to it, so maybe you could have a word mark that would protect the word itself in the context of a razor, as well as a separate trademark for the stylized logo and the way it looks. In terms of trade dress is similar to a trademark in that it protects product configurations that are associated with the source. What I always think of when I think of trade dress, for whatever reason, everybody has their own example, I always think of the roof on a Pizza Hut. Everybody knows what the roof on a Pizza Hut looks like, and when a Pizza Hut goes out of business and somebody else moves in there and they keep the same roof, everybody knows, oh, that used to be a Pizza Hut. Well, that design, that shape, is something that has become indicative of source for who owned that building. Similar here, I think it would be very tough to get trade dress protection in a consumer product like this, absent some feature on it that was really something that you would source with the particular company.
Yeah, I think that's right. I think whereas with a mark, if it's distinctive enough from the underlying good or service, you can register it or use it as a brand and get trademark protection automatically. But for trade dress, you're going to have to use it consistently enough over time so that people start to look at, oh, that razor tells me that's from a particular provider, such as the roof on a Pizza Hut. You can look at it, and they've used that consistently enough over time that now we all associate that with a particular pizza restaurant.
Yeah, another good example on a feature of a product that is entitled to trade dress protection. Our firm worked on a case for Wolf, and for people who are foodies or into kitchen equipment, Wolf is sort of a high-end kitchen appliance maker, and on their products they use red knobs. They are the red knob manufacturer, and so we successfully enforced trade dress against another company that had knocked off the use of those red knobs. So color kind of falls within that gray area between trademark and trade dress. I'd say it's more a trade dress feature, but that was one example where something that is consistently used by a company, and a company gets its, people know when they see that's from that company. That is a good use for trade dress.
So I have a question here from the website, and I just want to remind everyone that you can ask your questions on the website, or you can tweet them to @mconnects, add them into YouTube or the Google Hangout. This one comes from Sarah, who says that she designed a user interface and she wants to protect it, and she's thinking that might be a design patent. Is that correct?
Great question. We get these a lot from students here at U of M who are actively working on mobile apps, and maybe they don't feel strongly about their ability to get a utility patent on the underlying functionality of the software. So, Marcus, what do you think about other forms of IP that could be used to protect a user interface?
Yeah, I think copyright certainly plays a role. Because I think it's an easy one to get. I think the other, I think design patents, it's right on. There is an increasing volume of design patent protection that's being sought for user interfaces. Apple has some pretty famous ones. They actually have a design patent in one case that is not individual icons, but it is the entire look and feel of the iOS interface, the color scheme, the way that the icons have that sort of rounded square look. It's all in one design application. And you can certainly, and we've done this, go for sort of smaller segments of the user interface. So let's say that you come up with a series of unique icons. Each of those icons itself could be individually protectable through design patent. As I mentioned earlier, some countries treat this differently. Some do not allow design protection for user interfaces. China, in May, just allowed graphical user interfaces to be protected, with the caveat that they need to be protected in the context of the product. So if you had an iPhone and you had a particular icon you wanted to protect, you could protect that icon on there, but you also have to claim not only the icon, but also the phone on which it's stored. So it's a little narrower form of protection than you might be able to get in the US, for instance.
I think copyright's an interesting one to talk about, because sometimes I think people misunderstand the extent to which copyright protects these things. And am I right that copyright may protect the underlying source code, may protect particular graphics or compilations of graphics on the screen, but it's not actually going to protect the method of operation. I think there's probably a case that you and I read in law school, Marcus, the Lotus v. Borland case, talking about spreadsheets, and I think it was Lotus was trying to say that the file structure or the file flow chart, where you pull down the file editor view menu, which was blatantly copied verbatim by the defendant, said that's protected by copyright. There's several different ways to do it. We chose to use these words in this order, and that's protected by copyright. And they lost because it's a method of operation. It's how you interact with something, and copyright can't protect that. So you do have to be a little creative in using these other things.
Yeah, I totally agree.
So how about the trade dress or trademark? Is there any role for that in a user interface? In the Google screen, there's going to be the Google trademark name right across it, but absent using their exact trademark, is this a similar inquiry to kind of the shape of the handle of a razor, where someone would have to really develop that secondary meaning where someone associates that user interface with a particular provider?
Yeah, and I haven't seen any cases on this, but I think that in particular apps are interesting to look at from that. If you think of apps that you open on your screen, often they have some sort of a stylized logo to tell you what that program is. And if that's associated, like let's say the Stumble Upon logo, it's that sort of stylized SU with a red background. That's something that arguably could have some trademark wrapped up in it. So that's a possibility. There's an example of something that one could pursue potentially trademarks, copyright, and design protection all on the same icon, different aspects of it, which would give you differing layers of protection, different terms, different enforcement mechanisms, but it would be a robust way to protect something like that.
So, guys, we've talked about a lot of different forms of protection today, and I guess what I'm wondering when it boils down to it is, are they really as sufficient to cover your intellectual property as a patent is? In the end, if you had a combination of them, do they work as well as a utility patent?
Marcus, you want to start off with your thoughts?
So by that, Jennifer, do you mean if utility patent protection weren't available or weren't pursued, do those other forms of protection give you something of value? Is that the question?
Right, right. Let's say, for example, I am a startup and I don't have enough money to pursue a full utility patent. Or is pursuing one of these other options a good course?
It is certainly a course, and it's particularly a course when utility protection might not be available. I sort of, I'm a patent attorney, so maybe I have some bias to it. I certainly come at it from that angle a lot of the time. But in other cases, these can, by creating a thicket, an IP thicket of things that people would have to go through to carve market out from you, then I think they can have a very, very impactful and beneficial place in anybody's portfolio.
Yeah, and to flesh that out, but I think it may depend upon the nature of the technology as well. In the medical arts, certainly in pharma, you're going to probably find that a utility patent is close to essential, just because there's probably some very fundamental technology there, the composition of a new drug or treatment that you just have to protect, and because you can't keep it as a trade secret, you need to sell this drug into the market and have it clinically tested. Utility patent is the only real way to protect it, and you're probably not going to get any investment unless you can show a pretty strong plan for utility patent protection. But I think in other areas, particularly in software, particularly in social media, where maybe the fundamental technology isn't patentable under utility patent until you flesh it out and come up with some specific aspects that are patentable, you can go to market without a utility patent. I mean, two great examples are Facebook and Twitter, which, when they started to go to market and really grew, there was no patent on either of those. Since then, they've aggressively spent a lot of money pursuing patents. But when they first went to market, there was nothing that prevented someone else from going and using that same fundamental social media structure. And I think that gets to the strength of trademarks in that area, where there was other things that prevented someone else from competing against them: switching costs, first mover advantage, just operational excellence. And that's where the brand of Facebook, or the Facebook at the time, and Twitter really carried the day, because people associated, hey, this is where everyone's going, and this is where Ashton Kutcher is tweeting, and that strong brand recognition with Twitter and Facebook helped them. And then later on, when they had to start getting more creative with, let's patent the ability of refreshing the screen on a mobile device.
Yeah, I think Bryce makes an excellent point about it depending on the technology. And it's not even just for startups. There are very sophisticated, large, old companies that have products that don't lend themselves necessarily all the time to utility protection. And so they pursue design protection, copyright protection. And that is a way to approach these things. I do work for a large manufacturer of faucets. And unless there's some new feature within the faucet, typically we're thinking about this from a design protection standpoint, because their biggest business challenge is companies importing knockoff products that come to market very shortly after they introduce their product. And so one way to combat that is to have other types of protection in place to secure your place in the market for as long as you intend to have that product on the market. It might not be the full 14 years. Maybe it's only a 3-year product run, but you want to make sure you have it locked up during that time. There are ways to use other forms of protection to secure that place in the market.
Yeah, I think it gets us back to the notion of these, working together as part of an overarching strategy. Jennifer, was there another question?
Yeah, we just had a question pop up from Johnny. He's noticing that most IP suits seem to feature prominently in the media. They involve lots of large companies. Is there anything a smaller company should know early on about enforcing? Yeah. I'm sorry. I'm looking at this and I don't quite understand the question. He says the locale of major IP suits seems to often feature prominently in the outcome for those cases covered by the media. So is there anything that smaller companies should know about the locale of major IP suits, I believe is what he's asking.
Yeah, maybe getting at where people bring the suit. So, yeah, patent suits are always handled in federal court, but you can often choose which federal court where you bring the suit. It's usually very general as long as there's some tie to the defendant. And it used to be easier to be very selective where you sued someone. If someone was selling their product nationwide, you could basically sue them wherever you wanted. And there were certain forums that people perceived to be very favorable to plaintiffs, either because they moved quickly, maybe they had certain rules that tended to favor the patentee, or maybe the jury pool was perceived as someone that would be likely to uphold a government-granted patent. One of those forums was the Eastern District of Texas, and in Marshall, Texas in particular, which really just built up as a patent suit haven. Now the law has changed recently. I think it's a little bit harder to sue someone anywhere. I think the Eastern District of Texas is a little bit more aggressive at kicking out suits that don't have a strong tie to that jurisdiction. But there is strategy to it. And in fact, for a time, I think in almost every patent suit brought in the Eastern District of Texas, the first motion was the defendant trying to move out of the Eastern District of Texas, probably back to their home forum. Certainly patent litigation will be one where you want to get a seasoned patent litigator, and they can talk you through some of these strategies, because home court versus away court, travel costs, the typical schedule, all those things factor into this. But I think that's probably what the question was getting at.
Yeah, in fact, he jumped back on and did actually say Texas, so yeah.
Right. Yeah, if anyone's been to Marshall, Texas, it's an experience, beautiful town, but they love high school football and patent suits are really their two big lines of business.
All right, so we've talked about quite a few different types of protection here. I guess, do you have any advice for people starting up of what should be their process to craft their IP strategy? Where should they start?
I'll take that. I think first and foremost, you need to talk to somebody who's experienced in all the different areas who can sort of help you craft that strategy. There's not a one-size-fits-all approach. It's very much dependent on the positioning of the company, how early stage or late stage they are, whether they're going to have sources of funding coming in, whether they're going to be disclosing their product early on in the process, or maybe they're going to wait till later on. I think that there's a lot that goes into figuring out what the best form of protection is. Often the answer is getting a utility patent on file, but that's not always the case, and it's not always necessary. So partnering with somebody who understands what might be best in a given situation, who has worked with startups in the past, is probably something to consider, as opposed to somebody who only works with maybe large companies who have a different approach to things. But I think it is very much a custom, not one-size-fits-all type of process.
Yeah, just to add a little bit to that, I think, number one, you need to tie this to your business strategy. I mean, quite often people just think, a patent or some form of IP is just a check they need to add to their checklist. And, I mean, IP is a particular way of implementing your business strategy and giving you a competitive advantage. So what is your value proposition, and what differentiates you from your competitors? What's the reason why customers are going to pay for your product or service? And then what is the best way to protect that, the feature or item that the customers are actually going to pay for? That's what you need to be thinking about. And then there is a sequence to these that you'll often see come up. Patents are important because they're the ones that you can lose if you don't seek protection for those before you publicly disclose them. That's not quite as true for trademarks and copyrights. Trade secrets you can easily lose by disclosing them, but quite often, trade secrets are things that are developed as you start to run your business. Usually there's a fundamental aspect to your technology, either the source code or maybe some patentable idea, and then trade secrets are things you kind of build up when you figure out the best way to make those, the best way to market them, the best way to sell them, that you protect through the operations of your business. And design patents, too, again, it depends upon the nature of the technology, but quite often someone has a particular idea, but they don't know the final design for their product until much later in the process, and that's when design patents come into play, when you actually know the design of the product. So, I think the ability to tie these to your business model and your business strategy is important as well. not although we're sitting here today kind of talking about all 4 forms at the same time, sometimes the time to consider them comes at different times for a startup.
Yeah, and I'd add too, and maybe it's not the topic of this Google Hangout, maybe it'll be a future one, but something startups also need to be aware of is that while it's great to protect your own stuff, and you should do that, you should also be aware of what else is out there. And because that can tank your business very quickly. If somebody else has a patent that covers you or some other form of IP that covers you, that won't let you bring your product to market. So that comes in the context, if we're advising someone maybe to pursue some form of patent protection and a prior art search looks like it'll be valuable, analyzing those patents not only for what they disclose but also for what they cover is going to be an important part of sort of the suite of intellectual property that a company has. So being mindful that you're not the only one in the market space potentially is also something that will serve you well, particularly at the startup phase.
And that's actually a great segue to next week, week 3 of this program, where we will talk about the freedom to operate side. So it's a totally separate question from can you protect your technology through intellectual property is are you actually allowed to deliver your product or service to the marketplace and not infringe someone else's IP, and how to address those problems which inevitably arise, because there's a lot of IP protection out there in existence no matter how new your product may be.
So I think that was a great wrap-up. Thanks, Bryce. You just did my job for me. We're going to go ahead and end today. We hope you enjoyed our discussion. As Bryce said, next week we're talking about freedom to operate and the issues involved with that. You can get started on Monday by watching the videos and go ahead and ask your questions right at the bottom of the page. Bryce will be jumping in from time to time and capturing your questions, answering them right there, and then we'll be preparing them for the Hangout. Also, remember you can come back and watch this on demand at any time at the MConnects website. I want to thank you guys for joining us today. Marcus, thanks for joining us.
Thanks for having me. Appreciate it.
And Bryce, we will see you next week.
Sounds good. Thanks, Jennifer.
All right, and thank you all for watching. We'll see you next week.